Hello and welcome back to my channel. Thank you for watching today. Today we're going to talk about the permanency hearings. So the first permanency hearing is held by 6 months after the removal. Should be sooner than that. And then there's another one every 4 months until final trial or the child is returned and the case is dismissed. Now, there can be more than that. Those are the statutorily required ones, but the court can set more permanency hearings, set them more often. Sometimes courts will set what they will call like maybe a review hearing, which will function a lot like a permanency hearing, but it doesn't require all the statutory requirements because the legislature, every session, they add more stuff in. So sometimes they'll do a review hearing and just on some of the issues in between the permanency hearing. Others will do permanency hearings every couple of months. It just depends. So the initial permanency hearing has to be 180 days or 6 months from the date the court renders the temporary order. Now, just to get something out of the way on a lot of this stuff, what happens if they don't do it within 180 days? Well, not much. It can affect the department's federal funding. And you could, if the judge just refused to do it, probably get a mandamus from a higher court ordering the judge to hold a hearing. It's not jurisdictional. The court doesn't lose their jurisdiction. Your client doesn't automatically get the children back or anything like that. I have seen a case where a appellate case where the court refused to have an adversary hearing. The judge was familiar with this parent and just felt it was pointless and so wasn't going to hold one. They mandamused the judge and the court ordered they have a adversary hearing because the statute requires it. So just wanted to put that out there because sometimes, especially people that are new to these, always worry, am I missing something there by not filing a motion to dismiss or something? It wouldn't take a lot of research to find. There's cases out there that'll say it's not jurisdictional. So the permanency hearing the purpose is basically to see how things are going, how the parents are doing on the service plan, how the children are doing. You know, the children, there will be a plan for the child as well. It's not quite the same because it's actually with the children, it's even more unique than the parents from case to case. But a lot of the children that come into care need services. They might need special therapy, play therapy, occupational therapy, behavior therapy, lots of different things. And they'll have their own, and the court's going to review that, as well as just how the child is doing, if the child's in school, how they're doing in school, just general things like that to make sure that the child has everything the child needs and that they're entitled to under the statute and that they're being taken care of at least as well as possible. One of the things at the initial permanency hearing, the court is supposed to set a final hearing. Not all courts do that. And it's a little ambiguous. I can see how they might read that, but I think it's supposed to be done. But again, there's not much you can do other than mandamus. And if for some reason you need to have a final hearing date, you can probably go to the judge and say, Judge, we need to have one set for this reason or that reason. It doesn't come up, so I wouldn't worry about it. So again, after that, the permanency hearings need to be every 120 days or 4 months. So I've got a lot of the statute here that I wanted to kind of go over quickly just to give you an idea of what you're looking at. And this is 263-306 kind of has what the court is required to do. Identify all the persons and parties present at the hearing. Review the efforts of the department on locating and getting all the people that are entitled to service, that they are given service. Obtaining the assistance of a parent for finding an absent parent. The parents that are present are supposed to help the court and the department find parents that aren't. As you can imagine, parents aren't always helpful with that. Sometimes they don't want the other parent found, but that is a requirement under the statute. A parent has rights. And a father has just the same rights as a mother. An alleged father does not have the same rights, but an alleged father does have rights. And they have rights to notice of the hearing, notice that they might have a child, and an opportunity to engage and find out. They can ask for a DNA test and things like that. The court should review the parents' or parties' compliance with temporary orders, service plan, that kind of stuff. There's a report that is filed by the department, a permanency progress report filed by the department, which has a lot of information they're required to submit to the court and to the parties. So as an attorney for the parent or the child, you're going to want to be familiar with the report. As an attorney for the child, hopefully you're familiar with a lot of that stuff before it even goes into the report, because you should be monitoring the child as well and working closely with CPS and the guardian ad litem on that. But there's still going to be some information in there you're not going to have. The appropriateness of the primary and alternate permanency goals. So the department will have two goals, a primary and an alternate. They start off in almost every case with the primary being family reunification, and that's required by statute. And they can get that waived if aggravated circumstances are found early on, and that's for another video. But like I said, just about every case you're going to have family reunification as the first goal. An alternate would be family adoption, non-family adoption, another planned living arrangement or something like that, which is like the least favored. So you need to look at those, and then they can change. If the parents are not doing what they need to do, then they might change the goal and say our primary goal is adoption by this foster home, and our secondary goal is reunification. It can switch back, and I've seen that happen before. It doesn't happen that often. Parents that have done that poorly don't generally turn around like that, but they sometimes do. And of course, you might have an absent parent show up that wasn't around, and so that can do it too. But it is possible your parents can. There's always the chance to turn it around. Well, I say always the chance. And the closer you get to final trial or dismissal, the less of a chance there is. Whether the child has been provided the opportunity in a developmentally appropriate manner to express the child's opinion on any medical care provided. So a child gets a say in that. They also get a say in the placement, by the way. Of course, their age is going to make a difference on how much weight that carries, but they do get a say in it. And they're supposed to be asked if there's someone other than the parents that they would like to live with during this case. For a child receiving psychotropic medication, whether the child has been provided appropriate non-pharmacological interventions, so you need to look at those first as an alternative, and has been seen by the prescribing physician, physician assistant, or advanced practice nurse at least once every 90 days. So a child in the department's care that's receiving any psychotropic medication must be reviewed, must have a review with the practitioner, whoever that is, at least once every 90 days. I think that's pretty common among a lot of practitioners that prescribe that kind of stuff anyway, especially for children, but it is required in these cases. Whether an education decision maker for the child has been identified. So the court is supposed to appoint somebody to be the education decision maker. Now, quite often that may be the foster parent. Sometimes I see it be the guardian ad litem, usually the CASA volunteer. So that you need to make sure that that is done. For a child 14 years of age or older, whether services that are needed to assist the child in transitioning from substitute care to independent living are available in the child's community. So basically we're talking about if once a child turns 14, if they're 14 years old when they come into care, the department has to start working with them towards being independent and living on their own. And the reason for that is you don't know that the child is going to get returned to the parent. And quite often when they come in as teenagers, I shouldn't say quite often, but more often as teenagers, they don't, because there's issues that have something specific and maybe more long-term. But regardless, you don't wait till the last minute to find out if the child needs this. They start getting them those services. They're still working towards reunification. The child may go back. It doesn't hurt the child to get training on independent living. That could be good for any child. But the goal is to make sure because once they turn 18, if they're in the department's care, they can leave. And you can't force them to stay. You can't force them to stay in the foster home. You can't force them to stay in the department's care. So you've got to make sure that they're able to take care of themselves when they're 18, or at least do everything reasonably possible. If what I had mentioned for another planned permanent living arrangement, and that's the least favored because it means basically all the ideal options are not an option. And there's several things that the court has to make sure the department has done, including making sure they've had a independent living skills assessment and different things that are required under the statute. At the end of the permanency hearing, just like the adversary hearing, the court is required to return the child to a parent, or really the parent that was removed from it, not necessarily. I mean, usually you're looking at that, but return the child to a parent unless the department can show that there is a continuing danger. So again, it starts off with the child should go home unless there's a continuing danger. So you should know whether the department's going to recommend the child go home or not. And if not, make sure you know why so that you can argue for that. But the burden is on them to show that there's a continuing danger. Most often, that's going to be either you have a parent who is continuing to use drugs, continuing to get involved in criminal activity, things like that. They're continuing bad behavior throughout the case. Or they haven't finished their services. So what the department will say then is that they have not adequately addressed the concerns that brought the child into care. So if it was, say, a drug addiction and they haven't completed rehab, then the department's probably not going to, the department's probably going to argue that that's the continuing danger to returning the child home, even if they're testing negative for drugs. Because you got to ask, why are they testing negative? Well, if they're in an inpatient rehab, they probably don't have access to it. If they've been in jail for the last 4 months and just got out, they probably didn't have access in there, and that's why they're clean. So that doesn't necessarily mean they've addressed the addiction. That'll be the argument. Again, be ready for that. And you may know you don't have a chance, and that's fine. And you can talk to your client and say, look, we need to keep working services and tell the court, show the court how you're progressing and things like that. You may not get the child back this time, but we're closer, and we're going to let the judge know how well you're doing. And for the attorneys for the child, remember, Foster Care Bill of Rights, there's lots of things that are required by the department to do for the child, to provide for the child, and a lot of this is supposed to be reviewed at the statute. Ensure that the child has regular ongoing opportunities to engage in age-appropriate normalcy activities, including activities not listed in the child service plan. So you want to try to keep the child's life as normal as possible. That's one of the goals. It's one of the requirements in the statute. Now, if the child is placed with a relative of the child or other designated caregiver, that caregiver has to be informed the option to become verified by a licensed child placing agency to operate as an agency foster home, and the Permanency Care Assistant Program under Subchapter K, Chapter 264. So what these programs are for is to help assist for the caregiver to get benefits, foster care support, things like that, if they end up with the child long term. And now some of those programs are going away, unfortunately, but you want to be familiar with that and make sure it's addressed as appropriate, and that if any opportunities are there, that they're made aware of it. You can't force them to do it. And sometimes people don't. They don't need the money, and they don't want to go through all of it. But they should at least be made aware of it. The report I mentioned that the department is to file, the permanency progress report, is supposed to be filed 10 days before the hearing. I have worked in many counties, and I don't remember ever seeing that done on a regular basis. Require them to have it filed. They should have it filed 10 days. If it's filed the day before, that's not appropriate. I don't know why I don't see attorneys do this, but object. Say, I haven't had a chance to review this with my client. Now, granted, if your client has been absent and not participating for the last 3 months, you're not going to get very far. Don't waste your time. But if you have a client that's actually coming to the hearings, is actually engaging, that will actually meet with you, then insist on that time. You are entitled to it. And if it costs the department money because they go past the deadline, that's their problem and their fault. And just point out, we're required to follow the rules, they should be too. And hopefully, if that starts happening more often, the department will stay on top of that better. Now, if they file it 9 days before, I'm not going to make a stink about it. It's not a matter, technicalities don't rule in CPS cases. And there's no reason to be difficult for the sake of being difficult. But if it's not filed far enough in advance for me to look at, and this is done routinely, which is exactly what happens in a lot of counties, then yes, I'm going to raise a stink about that, and you should too. Try to meet with your clients ahead of time, review the service plan compliance. If you get a chance, try to build a relationship with the caseworkers, so they'll let you know what's going on. Also remember that sibling contact is important, and this especially goes to the ad litem, but for attorneys representing parents, that's probably important to them as well. So, and there are rules, and most judges will order that sibling visits be held. There are rare cases where siblings should not be visiting, and you can imagine some of those situations if you do these cases. But in most cases, siblings are better off being together, so you should try to have them placed together if possible, and unfortunately it's not always possible. But if they're not, that they have regular visits and regular contact, at least the opportunity. The greater the age difference, well, they may not want it as often, but still, regardless, it's good to have at least as much as you can and as much as they'll take advantage of. So there's the permanency hearing in a nutshell. As always, review the statute and make sure that you're familiar with and complying with all the requirements, and more importantly, that the department is, so that there are no surprises. Thank you for watching this video, and I hope you have a great day.